This is the American Law Journal.
And if you're getting workers' compensation and someone moves to terminate or modify your benefits, chances are it's your employer. But don't look now. Anyone trying to get anything done in the workers' comp system in Pennsylvania will probably find it a slow go. Good evening, I'm Christopher Naughton. Welcome to the program. And about twice a year, we try to get to some workers' compensation issues. Tonight's one of those nights. We'll talk about modifying and terminating benefits, but we can't ignore a very big issue in Pennsylvania right now, a new computerized system, and I'll have all three of my guests weigh in on this tonight. We'll see if the judge can weigh in on that, but let's go ahead and meet our attorneys. We sent out an APB, and we found Anthony Natale, somewhere in Philadelphia, defense attorney with Marshall, Dennehy, Warner, Coleman, and Goggin in Center City. And Tony, I guess we figured like 7, 8, 10 years since you've been here.
Yeah, it's been a long time, Chris. Thanks for having me back.
I was wondering if George or Sam and Martin Banks have perhaps scared you off, but no, it's been a long time.
I do battle with those guys every day.
You do. I know that. And of course, Tony represents the insurance companies and the employers. Marshall, Dennehy, of course, known for their civil defense litigation work across the country. The Honorable Timothy Bulman is with us this evening, first time up for the good judge, 5 years on the bench, seated in Philadelphia, workers' compensation judge in Philly. And George Badey returns to the scene of the crime. Once again, George, 30 plus years in the practice of law, representing those who have been injured, PI cases, med mal, and of course, workers' compensation. 1-800-426-4625, the number right here in the studio. If you'd like to get your question answered, call in early. Otherwise, we won't get to it. Write to us at info@lawjournaltv.com. We'll try our best to get to your question. All right, let's take a look at the proverbial elephant in the room. A $45 to $50 million computerized system instituted last September. It's known as WCAIS, the Workers' Comp Automated Integration System. And this quote from a recent Legal Intelligencer article: "To say it's been trying is a vast understatement. Frustration abounds from the practical to the legal among all who deal with the practice of workers' compensation, from judges to attorneys to claims adjusters to bureau employees. The brave new world of WCAIS has left no one unaffected." You're smiling, Tony. Is there truth to what Christian Petrucci said there?
Look, let me preface my comments today by saying, with any automated system of this size, we're going to run into problems. There's going to be glitches.
Yeah.
I'm of the ilk where I am hopeful that by the spring, the glitches are going to be gone and we're going to be able to actually litigate using this system, because it is a good system. But to say that there's no problems with it now, I can't do that. There are problems.
And to be truthful to George, it's been a lot worse than that. I've heard complaints from every kind of practitioner. I've heard it from judges. I'm hearing it from former judges. It sounds really more like a nightmare, even worse than Tony was suggesting.
There have been several horror stories about things not being filed, not being located, but for a change, Tony, we agree. I think it's going to be all right eventually. Okay. I think it's a great system.
It's a long
in the end,
show tonight. I'm sure we'll disagree.
Well, and here's the we'll get there, I'm sure. But maybe it's like Obamacare. Noble in its intention, lousy rollout, but give it some time, it may end up working. Judge, if you can, to the degree you feel comfortable answering these questions. We try never to put a judge in a political hotspot on the program, but how is it affecting some members of the judiciary? I mean, things are slowing down, right? I mean, I've heard from judges that, would normally do maybe 20 to 30 decisions in a month are only getting, it's just trickling out. It's not coming out in a stream.
Well, first, Chris, thanks for having me on the show. Sure. I appreciate it.
Good to have you.
I want to put this in some perspective. Our old system was a system that was developed in the 1980s, and it was kind of akin to a 72 Chevy that was held together by duct tape, and you change the oil every 100 miles or so. It was really an antiquated technology. The new system, the WCAIS system you mentioned, is high tech. It allows the attorneys, it allows the injured workers, the claimants, to directly see their case online. None of that was possible under the old system. So they're definitely, this is the iPhone 5 type system. It's very modern, very IT tech. Of course, though, like any big system, there have been some glitches, there have been some delays. And all I can really say is, we're constantly getting updates. They call them enhancements to improve the system. So I use the new system every day. I think it's getting better every day. So I am optimistic it's going to be on track very soon.
I mean, really what we're trying to do is get rid of paper, right? We lawyers kill so many forests. I mean, in some ways, this is like everything. We're trying to make things quicker. We're not trying to push as much paper. I mean, we're called paper merchants, et cetera. We've heard it, all the ways we've been described over the years. But I mean, that's really what we're trying to speed up the system, trying to get away from paper.
That's right, Chris.
Okay.
So the Bureau is trying to work with people and work with the judges, and everyone's trying to cooperate. So I think ultimately it's going to work out. I'm glad they've done this. I'm glad they've made this move to this automated system.
All right, let's talk about the pragmatics here, though, because if someone is your client, Tony, all right, and he feels that he's got a good termination case, hey, we've got the goods on this guy, it's time to get rid of his benefits, because this WCAIS system is working so poorly right now, your client says to you, Tony, I'm still paying benefits on something that should have been axed a while ago.
You're entirely correct, Chris. That's the problem that we're facing on both sides of the fence right now. And on my side of the fence, we are paying benefits every week. We are a disability state. Every week benefits go out, and every week benefits go out. My client is getting poorer and poorer.
Oh, my heart is bleeding, Tony.
At the same time, if decisions are sitting there and the judges are writing these decisions ready to go, and they're not getting sent out, it waves a flag that something's wrong with the system. Right. Let's all get along. Let's get this system rolling. And there's things that we can do as attorneys to work together. If I have a petition to compel physical examination and George's client is willing to go to the exam and the only thing holding it up is that we don't have an order in place right now, call me up.
We've worked things
call
out
me
like that
up
before.
and tell me my client's going to go and I'll get the exam scheduled, and we got to work together.
Right, and it's hurting your people probably. I mean,
way worse.
No one's gonna cry as much for a large corporation or insurance company. We understand that that's how it works. But when it comes to your client, I mean, literally, and you were quoted in the paper, but George, you could have said it, that people literally could be kicked out of their homes.
There is a human toll to this thing. There's a human side to this thing. Tony says, oh, my client's going to be poor. I don't think so. But what happens is there's a thing called the supersedious fund. So when Tony comes in, he files a petition, and there's a supersedious denial. If there's a delay in the case and he ultimately wins, his insurance company gets all their money back. On my side of the fence, if we file a claim petition, a person is without income for maybe months and months. They could lose their home. There's been foreclosures. They get evicted if they're renting. It has a severe human toll. So from our side, delay is deadly.
Right, and it's going to hold up settlements as well, right?
Well,
it could maybe not.
The way some attorneys settle cases, it may. The way I settle cases, the way George settled cases, it's not going to hold us up from negotiating, but it's certainly a problem. We can't put our head in the sand and say there isn't a problem here. I'm hopeful that the problem's going to be corrected in 2014.
And again, I'm just quoting Kristen Petrucci from that Legal Intelligencer article. Ultimately, the goal of the system remains, greater transparency, 24/7 availability online, as the judge was saying, faster claims processing and litigation times, and a more efficient adjudication system. We'll be watching that, Judge, no doubt. Let's talk about some of the areas. And you guys, I know, go head-to-head. You have gone head-to-head. In fact, just a week or so ago, I think someone told me that they thought one of the two of you was going to die in the courtroom, that somebody was going to someone was going to be murdered. I don't know which. But I also heard that not long after you guys duked it out in the courtroom, you were there in the hallway, chatting and laughing and that sort of thing.
Let me tell you something. The workers' compensation law is serious. The cases are serious. George and I go into the courtroom and we butt heads. George bleeds, I bleed. We make each other bleed. We enjoy it. We enjoy it. We say what we have to say. But when we get in the hallway, we shook hands last week before they brought the police up to try and separate us at the hearing. We shook hands in the hallway, and we said to each other, George, what did we say to each other? That's the way you're supposed to litigate these cases.
Well, and the reason I bring that up is because when it comes to modification and termination, this seems to be some of the more emotionally gripping aspects of work injury, because someone's gotten workers' comp, they've been on workers' comp, they feel like they should still be on workers' comp, somebody feels like they shouldn't be. So now this may even be more emotional than at the outset when someone files. No?
Well, yeah, because my client's receiving benefits.
Right.
My client's family is dependent upon those benefits to pay the rent or the mortgage if they're buying a house, to put food on the table. It's a very visceral, close to home thing, very heartfelt.
Right.
On Tony's side, he's got the multi-billion-dollar insurance companies that might be able to have to wait a little bit longer to get their money back. So for my clients, it's a very serious personal matter. Tony takes it seriously too. We go into court, we argue the legal issues forcefully, vigorously, and people think we're mad at each other. We're not.
Right.
We're just professionals.
But I mean, Tony, this is where, the whole notion of malingering or people who have been on comp and don't need to get back, and I know that George probably doesn't believe it, but that there might even be some good deeds done by the corporation saying, look, it's time for you to get back to work. You're going to be happy you're getting back to work. We've seen other people stay away from work too long. Everybody ultimately wants to work, more or less.
Chris, maybe what George isn't seeing here is 90% of the cases that these big billion-dollar insurance companies deal with, we never see in a courtroom. The fights that we have are over about 10% of the cases. Workers' compensation isn't designed for you to be on workers' comp for life. There becomes a point in time where claimants need to go back to work. Now, I don't have problems with George's clients, but I have clients out there whose treating physician releases them to go back to work. We make a job offer to them within those restrictions. And what does the claimant do? Go out, find another doctor who certifies their disability. They're the cases I get involved in. They're the cases I'm coming for you if you do that, and be afraid. Be very afraid.
Judge, do you find that these are a little bit more emotionally ratcheted up than, let's say, a fresh petition?
Oh, absolutely, Chris. The termination petition is sort of, as the name implies, it's a finality. The insurance company is trying to end the case. The claimant's benefits, both their wage loss and medical, are going to be terminated or ended if the employer insurance company is successful. So the stakes are very high. So there is a lot of emotion in the courtroom, both the attorneys, the injured workers. It could be emotional, there could be tears, there could be anger. I will say, again, with the termination petition, while an injured worker is facing, the extreme kind of remedy of losing their benefits, what they could take some comfort in knowing is that the burden on the insurance company or the employer is very high in those cases. They have to prove that the injured worker is fully recovered, 100% better from their work injury. That's a very difficult burden. So these cases are emotional, they're tough cases, and the lawyers do an outstanding job.
I like when they file a termination petition. I prefer a termination petition because, by and large, the vast majority of the termination petitions that are filed have a doctor to support them. That's an insurance company regular. We have the book on a lot of these doctors. They come in and they say everybody's totally fully recovered and able to return to work. So when you have a doctor who says that 60, 70, 80 times a year and is paid hundreds of thousands of dollars to proclaim everyone fully recovered, it's not too hard to blow holes in his testimony. And when they're trying to terminate, which is the most drastic remedy of all, completely cut off all benefits, their burden is very, very high, and it's easier for us to win. A more difficult case may be where Tony sends a job offer with a large employer and says, your client could come in and do this job where he just sits at a table and doesn't do much. That's a harder case for us to defend. The termination petitions I love because they're easier to beat.
Chris, I have to take a little bit of umbrage with George because I'm so sick and tired in this system of claimant attorneys stating that defense doctors are hacks. There are just as many, if not more, claimant oriented physicians out there. And I'm not saying George uses them, but litigation is a big place. There's a lot of attorneys, and there are certainly a lot of claimant hacked doctors out there that will certify a claimant's disability.
I'm sure you'll raise that to a Judge Bulman if that occurs.
Definitely.
Right.
And the other thing I want to say is when claimants get used to being on workers' compensation and they don't want to go back to work, they will do a lot of things to stay on workers' compensation. Examples, Fast Eddie claimant drops a traveling alarm clock on his foot because he had a toe injury and he doesn't want to go back to work, so he wants to make the symptoms look more enhanced. These are actual people that I deal with day in and day out. Come ride with me in my car to all of these hearings and you'll see some stories. They might not be George's clients. George is on the up and up. I told you, he's a great attorney, but there's a lot of claimants I see that are...
And that's why sometimes you guys actually have to go out and perform surveillance because you feel that you want to terminate, you want to modify, maybe George or someone like George has got a good doctor for his client, and now you guys have to do something a little bit more extraordinary.
Great point, Chris. Surveillance is used in termination petitions as a routine now. You know why? Because if it's doctor versus doctor and both doctors possess the same qualifications, A tie usually goes to the runner in this case being the claimant. The act is humanitarian in nature, so the judge is going to give the benefit of the doubt, so to speak, to the claimant. So we need something else on our side to show that this particular claimant is fully recovered, and believe me, surveillance video can clinch a case.
Surveillance sometimes goes to our benefit.
I was just going to say that, but I'll let you jump in. Go ahead.
I've had cases where they've had my client, they're following my client around and they're not doing anything. Nothing's going on. I had one case years ago where I had a 50-year-old claimant and an 80-year-old mother of the claimant coming out of the supermarket with the cart. So they get to the trunk of the car and the 50-year-old claimant opens the trunk and we're waiting to see who lifts these heavy bags into the trunk. It was the 80-year-old mom. So that helped clinch our case. And we've had other examples where surveillance helps us.
And you've got to disgorge that tape.
Well, no,
Tony would, because Tony plays by the rules.
Tape. If the tape comes in and it doesn't show anything that's helpful, I will still supply that to George. But I get a ton of tapes every week where a claimant will testify before Judge Bulman or any other judge in Philadelphia or the surrounding vicinity that their back pain is so bad that they can't even get out of bed. And what do? We have a surveillance tape of a claimant who is acting as a professional wrestler and lifted a 200-pound man over his head.
Well, those people deserve to be cut off from benefits,
now
and nobody's going to argue about
that. I got to go to the DA's office, and I got to prosecute this guy.
That's a rare case.
I was going to say few and far between.
Not that rare.
All right. Let's take a quick look. By the way, again, we're going to get to your phone calls in just a moment. 1-800-426-4625. Let's take a quick look at this graphic of what really triggers terminating or modifying workers' comp benefits. And again, it's largely a tool for the employer and the insurance company. And what usually triggers it is a job offer, as George was just mentioning a while ago. Maybe you can't do the job you used to do, but maybe sitting at a desk, not doing a whole lot. There is a job offer on the table. Earning power evaluation, those restrictions have become more lax for employers over the years, so now it's easier for Tony to get an evaluation to get his case moving. And then, of course, the IRE, which is an impairment rating evaluation. The IRE is really about going back to a doctor and measuring whether or not you can do what you used to be able to do?
Well,
just how badly impaired you are in general.
It's a 500-week limitation if you're found to be less than 50% whole body disabled. And the standards that they use were not ever intended to be used in this way. But again, it goes back to politics. And when we had a Republican administration in, they made these so-called reforms that saved the insurance companies billions and billions of dollars. And people can be very severely injured and disabled and be less than 50% whole body impaired and still not be able to work, yet their benefits will be cut off after 500 weeks. That's just not the way the system was designed to work.
Chris, I want to say that my clients who save money are clients that have the ability to bring injured workers back into the workforce in a restricted duty job via a job offer. That's my number one concern in my cases. They're the modification petitions that I go to bat for my client, and I'm throwing punches as soon as I come in the courtroom. I don't use IREs all that much. I'm the wrong attorney to talk about that, and I'm not saying my brethren out there who use IREs and use it successfully are doing something wrong. I don't use them because if I go back to my client and I say, hey, I just limited this case to 500 weeks, I'm not going to get a kiss on the cheek for that, okay? I'm going to get a slap and get back into court and get this thing rolling.
I knew things were tough for defense attorneys. I know there's a lot of competition out there. Judge, is this the kind of thing that, you see this kind of played out in front of you when you've got a modification or a termination matter where, George and Tony talking about really what's at stake, how intense it is, and I know you answered a moment ago dealing with the emotion, but what is it like being in that courtroom, especially when you've got two attorneys who are really going to the mat for their client?
Well, I mean, it's interesting at one level. I take my job with a grave responsibility, so I have to ferret out the injured workers who may be exaggerating or possibly committing fraud from the generally severely injured workers of Pennsylvania. So I have to look at these cases very closely. I generally have the opportunity to view the injured worker testify live before me in court, so I get to sort of size them up in court.
I see. And you find that employers are now showing up in court more than they used to, right, Judge?
We get a lot of representatives from the different companies, the different employers, come to kind of watch what's happening in court. They want to hear what the injured worker is saying, so maybe they could present some other witnesses from the employer to contradict what they may say, or just to kind of be there as a representative. So, I think that has been increasing lately.
All right, let's go to the telephones. Omar is up first tonight. Omar, what's your question for our panel?
I just wondered where the importance of the independent medical evaluation is so powerful that it overcomes your primary care workman's comp doctor that the insurance company chose and specialists that the insurance company approved or chose. When it comes down to talking and even treatment on some levels, you get treated a different way because of something that some doctor says that saw you one time.
Let's talk about where the IME is in the process and then answer Omar's question.
We don't call it an IME. I mean, I know they like to call it an IME. Tony likes to call it an IME. I call it a DME. It's not an independent evaluation. It's a defense medical examination. It's a DME. It's a doctor handpicked by Tony or some other insurance person, and they know he's going to favor them because they're not going to send people to somebody that's going to cost them money. So number one, that's right off the bat. Secondly, if your treating doctor says something, that opinion is entitled to greater weight than the opinion of a defense medical or an independent medical examiner. So that's actually not true. Your doctor's opinion is entitled to greater weight. And unfortunately, sometimes the defense wins these cases when they shouldn't. So Omar, I can sympathize with you, but it's not necessarily the case where they take their opinion higher than the treating doctor.
Chris, look. An independent medical examiner, defense examiner, whatever you want to call them, is performing an examination on the claimant and arriving at a diagnosis in the case. Treating physician is doing the same thing. Judge Bulman or another judge will review these doctors' qualifications, review their cross-examination and the direct examination, and make an opinion. Now, George seems to think that if the treating physician testifies, the judge has to believe the treating physician, or the treating physician is always on the up and up, and the defense doctor is some cretin that we found under a rock. These defense doctors are paramount in their fields. Nowhere in any other state do I see myself getting a board-certified neurologist to testify on a very serious traumatic case, and the claimant shows up with a chiropractor, and they actually have to determine which one is more credible. Okay, I think everyone would agree with me that a neurologist versus a chiropractor, I'm supposed to win.
Unless the neurologist is making $1.5 million a year to testify 4 times a week, and he gets paid $5,000 to $10,000 a pop. I've had it happen.
How much money are the treating physicians in this system making? These treating physicians are making more money than the DME physicians, if that's what you want to call them.
I think Judge Bulman will agree, though, that the case law says the opinion of a treating physician is entitled generally to greater weight than one who only saw a person one time. Doesn't mean he has to accept that opinion.
And it doesn't mean that we should fold hat and run away.
No, you never do that, Tony.
Judge, I don't know if you want to answer that question. George made an assumption on your part. I don't know if you'd like to address that or not.
Well, sure. I mean, I wish my job were so easy to just say that the claimant's treating doctor is always more credible than the defense doctor. It's not that simple. Sometimes they are, and sometimes George's points are correct that who knows the claimant better than his own treating doctor or her treating doctor. But on the other hand, as Tony's saying, sometimes the defense doctor is eminently more qualified. They could be teaching at the University of Pennsylvania. There could be all sorts of things that might lead me to believe they're more credible. So each case is different. Each doctor's different. I look at it closely, and then I have to make that decision.
We're going to get to more of your phone calls. Willie, you're up next. We want to remind you, can't get to all of them in the first half hour. We're going to be staying here in the studio for at least 5-10 minutes after the show. Continue to call us. There's a number, 1-800-426-4625. We'll take your phone calls off the air. Willie, you're up next. Are you there, Willie?
Yes, I am.
Go ahead. What's your question for us? Fire away.
Yes, when I was working for my employer, I had a couple claims to workman's comp. And back in December, I went back to see the doctor concerning one of my injuries. I retired from my job on January 29th. About 2 or 3 weeks later, I got the bill from a therapist that workman's comp was not going to pay my bill. So I called workman's comp. They told me they're not paying it because I waited too long in between visits to the doctor. When I talked to my doctor about that, they said in Pennsylvania they can't do that. Can they shut my claims down without notifying me for that reason, or can they not?
Okay.
They cannot, but it also depends, Willie, on what status you were in. Did they ever really accept that claim up front, or did they never even take a position on it or deny it? So if your claim was accepted and you received benefits, then they can't just shut it off with doing nothing. And I'm sure Tony would agree with me on that.
Yeah, I actually agree with counsel on this, but I should say to this gentleman on the phone that we don't know the facts of your case, but you need to go to a lawyer, okay? A lot of parties on both sides of this litigation think that they can surf this workers' compensation wave without an attorney, and employers need attorneys, and I'll dare say it, claimants need attorneys as well.
Thanks for your telephone call. Let's get to one of your emails as well. This is from James in Copley. I received workers' comp about 6 months ago, and the prognosis at the time was that I would miss about a year's worth of work. Now my company's saying I can work. They want me to go back to a doctor so they can send me back to work or end my benefits. My doctor says I still cannot work, and they want to pull me back in and modify my benefits. You've never heard that fact pattern before.
That happens every single day. And that's why you need to get a lawyer, because you need to be able to prepare for that onslaught. Tony's coming after you. You got to have somebody in your corner to stop that from happening.
And Chris, I want to say that fact pattern is a little bit different than what I see every day. What I have been seeing more and more, fortunately not with George, because I don't want to butt heads with George every day, but the fact pattern I'm seeing is that the treating physician is releasing the claimant to go back to work, and the DME, the defense medical examiner, is releasing the claimant to go back to work, and the claimant is seeking a third opinion from a different doctor to certify their disability, and that we cannot put up with anymore in this system. And I'd like to hear if the judges think that that is a case where the claimant's credibility may be in question. Judge.
Ask the judge. Go ahead and ask him.
All right, Tony. Again, all these cases are fact-specific, but that's certainly things we look at. I mean, the judges are real people. We're deciding real cases. We're looking at how people choose their doctors, what kind of doctors they're going to. Are the doctors helping the injured workers? Are the injured workers getting better? Or does it seem like it's just treatment that's just going on and on and on, and there's no improvement, but the injured worker's still treating there? So we look at all these things as judges, and then ultimately have to decide, which medical evidence is more credible.
Guys, I'm hoping that when we get together sometime in 2014 that you'll say, wow, this whole WCAIS thing has worked out. The system has filtered, things have filtered out. I understand right now that when you try to download evidence, it only downloads 10 pages at a time, or that's what you've been faced with. And of course, you said to me you had a short deposition, only 30 pages. It probably took you a half hour to download that.
Right. I mean,
that's
luckily I have staff to download it, but it takes a while.
That's a nightmare. But once it starts working out, Tony, what does it look like?
I think if this system works out the way they say it's going to work out, this is going to be a great thing, even considering Judge Bulman's comment about what the previous system that was in use was like. This is going to be a godsend if it works. So let's get out there and let's hope it works. To quote JFK, the late JFK, we don't do these things because they are easy. We do them because they are difficult. That's why we're in this system.
George, you got 20 seconds.
Oh, no, I think, I can't believe we're agreeing. We're agreeing on something. It's uncommon unless it's about the Phillies or something.
Wait till next week, right, Tim? Right, Judge? Then they'll be fighting once again.
Oh, I'll probably see him tomorrow in court.
Very good. Thank you. Judge Bulman, again, joining us tonight for the very first time, sitting in Philadelphia as a workers' compensation judge. And right here on the panel, Anthony Natale from Marshall Dennehy, representing, he's a respondent's counsel, again, from Marshall Dennehy in Center City, Philadelphia, squaring off, as he does often in court, against George Badey, who has joined us for many years here, representing claimants in workers' compensation matters. For all of us here at the American Law Journal, thank you for joining us this week. Keep calling 1-800-426-4625. Until next Monday night, case closed.
This week's American Law Journal has been made possible in part by Badey, Sloan, and DiGenova. Decades of experience providing personal attention to those injured at work or suffering from serious injury due to medical malpractice, defective products, motor vehicle accidents, and other causes, with offices in Philadelphia and Haddonfield, New Jersey. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.